টাকাটা দেননি কেন?
টাকাটা দিয়েছি,
না দেননি পুরোটা।
আমি দিয়েছি 10,000 টাকা।
আপনাকে যখন রুল ইস্যু করা হয়েছিল কন্টেম্পটের, আপনি হাজির হননি কেন কোর্টে?
ও হ্যাঁ, আমি তো হাজির হয়নি।
ওয়ারেন্ট অফ অ্যারেস্ট ইস্যু করতে হচ্ছে, পুলিশকে ট্রাভেল দিতে হয়েছে। Please take him to custody and put him in prison. Arrest was not clarified, so therefore department
But
has...
I understand, I met the police officer, I understand he has been brought. He has been brought to court pursuant to
Let him be brought. What was the allegation?
allegation. My lord's direction was for payment of arrears in 6 installments and 10,000 rupees per month as Alimony pending, and my lord 20,000 towards litigation cost. I understand after passing of the order, application was made.
Officer, you have brought the contempt, na?
Yes.
Yes. Yes, please continue, sir.
My lord, only my lord direction was like that. I understand from the date of passing of the order by your lordship, only 30,000 at one point of time and 10,000.
Where is the contempt now? Bring him before the court.
আপনাকে সামনে আসছি।
টাকাটা দেননি কেন?
টাকাটা দিয়েছি,
না দেননি পুরোটা।
আমি 10,000 টাকা দিয়েছি।
তাহলে আপনাকে কন্টেম্পট আমরা রুল ইস্যু করেছিলাম, আপনি আসেননি কেন প্রথমবারে? ওয়ারেন্ট অফ অ্যারেস্ট ইস্যু করতে হচ্ছে, পুলিশকে ট্রাভেল দিতে হয়েছে।
ওটা আমার ওই দিয়ে দিয়েছি,
হ্যাঁ,
আমি দিয়েছি 10,000 টাকা।
আপনাকে যখন রুল ইস্যু করা হয়েছিল কন্টেম্পটের, আপনি হাজির হননি কেন কোর্টে?
ও হ্যাঁ, আমি তো হাজির হয়নি। আচ্ছা,
Is anybody representing him?
Earlier one, my last friend.
So why are you sitting back? You come up forward. So has he any assets?
Only building.
But I tell you, lordship, Lord, there is a two-storied building. My instruction is, Lord, there are 3 rooms in each story.
In contempt you cannot attach, you
Yeah,
can only send
that's
him
it.
to prison. We'll send him to prison since he has not complied.
My lord,
If that suits you,
willful violation, my lord's
we'll
report
send him
is
to prison, no difficulty.
My lord, that your lordship will consider, my lord, that will not serve the petitioner's purpose.
You have filed a contempt application.
Of course.
In contempt you cannot pass
And
him
my
further order.
specific prayer
This
is that.
execution.
My specific prayer is
He
that.
cannot pay fine since he is not paying alimony. He has to go to jail then. What can be done?
My lord, I had a suggestion. Your
You
lordship.
levy execution separately for attachment of his property.
Yes.
Do that. We'll give you
That's
that liberty.
Yes, yes.
But for contempt, he has to go to
Yes,
jail.
of course. Yes.
What was the order? Let us see the order first.
My lord, the order is of
Contempt
contempt. My lord, that is in the contempt application, my lord, the order dated. I give your lordship the order. Yes, the order at page 14 of the contempt application. And the relevant
That is paragraph 9.
paragraph 9.
9 and 10.
Yes, 9 and 10. Litigation cost not paid. Up till now, my lord, only in aggregate 50,000 has been paid, no arrear.
The arrears of alimony calculated at the rate of 10,000 has not been paid.
Yes,
By 6, not a single installment.
not a single installment.
He says he has paid 10,000.
Per month. Next, your lordship has said,
So he has paid one installment then.
no, he has paid 30,000 at one point of time and 10,000. Aggregating
So
to
6
50,
equal monthly installments, what does that come to?
that has not been paid.
And also this litigation costs have not been paid.
Litigation cost not paid.
Yes, sir, we'll direct him to be taken to custody and send him to prison right now.
Only kindly see the passbook. He has no money. Only pension, my lord, 22,000 to 20,000.
There's an order of the court. You could have filed a review. You could have challenged before some forum with legal aid. You have several remedies. He has no money, is no difference in a contempt.
My lord.
And we issued a rule. He did not appear in court.
Yes.
So he's in double contempt actually.
That's why I am not.
No, you may appear for him, no difficulty. You are not in contempt.
My last occasion, my lord, 6 months switch off. Now I asked him.
No, he is deliberately doing it. Some people should learn.
My lord, he is totally.
My lord, the greatest humility, my lord, in earlier.
Confusion will be
also-
cleared right now. He'll get time to ponder on it by himself in prison.
In earlier occasion also, my lord, a coordinate division bench of this honorable court, my lord, for the same reason, because of his non-appearance, directed the police to bring him to court. This is the second occasion.
The contemner has been personally brought to court by the concerned police authorities as per the warrant of arrest issued by this court in terms of a rule previously issued for contempt of court by way of willful and deliberate violation of the order dated April 8, 2025, passed in IA number CAN 2 of 2019, within bracket old number CAN 6346 of 2019, in connection with FAT 299 of 2019, whereby the contemner was directed inter alia to pay current alimony at the rate of 10,000 per month starting from April 2025, full stop. Arrears of alimony, calculated at the rate of rupees 10,000, from July 2019 till March 2025,
Yes.
was also directed to be paid to the appellant wife by the respondent husband, within bracket contemner, bracket close, by 6 equal monthly installments, payable by the end of each month. Full stop. The first of such installments was to be paid by April 30, 2025, and thereafter by the end of each succeeding month. Full stop. Over and above the aforesaid amounts, the respondent husband, bracket a contemner, was also directed to pay to the appellant stroke wife litigation costs of rupees 20,000 within May 31, 2025. Full stop. Next para. However, despite such direction, the contemner himself admits before us that only a paltry sum of rupees 10,000 has been paid by him. Full stop. Next para. Moreover, in
No,
gross defiance,
Not 10,000,
50,000
50,000 in aggregate.
50,000 in aggregate has been paid by him. Full stop. Next para. Moreover, in gross defiance of the rule issued by us in connection with the contempt application, the contemner avoided to appear before this court on the returnable date, due to which we were compelled to issue a warrant of arrest for the contemner to be brought personally to court. Next para, learned counsel for the petitioner submits that for such similar recalcitrant attitude on the part of the contemner on a previous occasion, a coordinate bench had also to direct production of the contemner in court by issuance of warrant of arrest. Next para, thus, the defiance of the order of this court by the contemner is palpable and willful. Next para, we do not see any mitigating circumstance, since in the event the contemner was aggrieved with the order passed by this court, several avenues were open before the contemner, either to file a review application or to go up in challenge before a superior forum, if financially indigent, through legal aid services. Next para, however, the contemner having not done so on the one hand, and on the other, having deliberately and willfully flouted the directions of this court, no option is left to the court but to penalize the contemner for such deliberate defiance of the order of this court. Accordingly, the contemner be taken to custody immediately and be put behind the bars. The contemner shall remain in incarceration for a period of 1 month from date. The rule is accordingly disposed of in the light of the rule being CRC 21 of 2025 is accordingly disposed of in the light of the above observations. Next para, it is made clear that nothing in the above order shall prevent the appellant wife to have the order dated April 8, 2025 implemented through execution by due process of law in accordance with the provisions of law available in that regard. Please take him to custody and put him in prison.
Lord, I'm sorry, Lord. I personally express my sorrow for this old man to be taken to custody. However, my lord, only one thing, my lord, in earlier occasion, my lord, a legal aid was given by a coordinate division bench.
Do you think our nerves are of steel? We also have our moments, but we cannot do that in court.